By the way, this class is being recorded for the benefit of Coldwell Banker George Realty only. It is just for training purposes. I don't offer no legal advice. I am the manager and I will just training my agents. So this one is an instructions from the seller to exclude the property from the multiple listing service, right? And I don't like it, you know, but sometimes, I mean, if you want somebody that don't want to get the most money for their property, you might want to do this, right? So this is an addendum to the listing agreement that it was dated at the day of the listing agreement. Let's say today, the property known is going to be 1, 2, 3, 4, 5 Training Street. Right? It's in the city of Alhambra, California, 91801. And Sally Seller is the seller, and Coldwell Banker George Realty is the broker, the real estate agent. Multiple listing service, I belong to CRMLS, okay? This is the multiple listing service. California Regional Multiple Listing Service is the one that we all belong to. And then he has information. He tells the seller, hey, Mr. Seller, there are benefits of using the MLS. You know, if you opt out of the MLS, you will not get as much exposure of your property, okay? So it also tells them you may not get information, you know, the property is not gonna be exposed, limited exposure of the property, no marketing, no advertising of the property to the public will occur. Real estate agents and brokers from other real estate offices and their buyers who have access to that MLS information may not be aware that these properties offer for sale. You know, information about seller's property will not be transmitted from the MLS to various internet sites. So when you list and you don't put it on the MLS, your property doesn't go into the internet. It is just like a private transaction. Usually will be just to put it into the company. And I believe that the more you expose the property, the chances that you sell it for more money. I mean, it's if I were to be selling a set of keys and I don't show them to you, you don't even know that the keys are for sale, right? So I have a set of key. If I hide them under my desk, nobody will see them. So if you put it on the MLS, then you're showing everybody, hey, I have a set of keys here. You know, who do the key belong to? Somebody's gonna say, oh, it's mine, or I wanna pay more for that property. So I don't like this form, but sometimes we have to do that, right? And now there is another one that the MLS, our MLS, requires that we sign this MLS cooperation policy. And for those of you that understand it well, you know, our MLS requires, okay, that the broker participating in the service to submit so you technically have to submit it to the MLS and you have to submit the form saying the seller doesn't want me to put it on the MLS, but the listing agreement have to be sent out to the to CRMLS, and I don't like that. I mean, if you're gonna do that, something's wrong, but you know, that's okay. So our MLS has adopted, you know, the Clear Cooperation Policy, or MLS. NAR wants us to participate on that one. I don't know, maybe there are other MLSs that don't have this National Association of Realtors cooperation policy, okay? So the seller says, I wanna exclude the property for a period of 7 days, right? So for 7 days, I wanna paint the house, no problem, right? So we do that. Or you could always say, I don't want the property to be listed until, and we say, I want it to be October the 1st, right? That's okay, because between now and October the 1st, I'm gonna be painting the house or whatever, right? And you wanna secure the listing. So in the event that the neighbor finds out the property's out for sale and the neighbor makes an offer, we will get paid on an exclusive right to sell. So that will be the second choice that we have. We don't want it in the MLS for 7 days or 10 or 9 or whatever days you want, or until, and we have a calendar day that we wanted to put the property on the market, or the seller says, hey, I am a famous rapper. I sell my property in Compton and I don't want anybody to know that my house is out for sale because I'm afraid they're gonna come and shoot me. So there it is. No, don't worry about those messages that I say. But anyway, I don't want the property to go in the MLS during the entire period on this agreement. Okay. As I say, I disagree with it, but that's the way it goes. I wouldn't take a listing unless I put it on the MLS. That's my decision. And then the seller instruct the broker to exclude the property from the MLS. This paragraph applies unless 3D is signed. So you sign it over here. And they tell you, do not market the property, begin marketing it to the public on such and such a day. That's another way. I don't want it to put it on the market. I don't want people driving around my house or showing the house or whatever. Or I do not market the property to the public during the entire period. I don't want you to market it. And that means do not put a sign that says coming soon, because to me, that's marketing the property, okay? And then the seller will sign over here. And this is an agreement between the seller and Coldwell Banker George Realty, and you are signing on behalf of the company. So I will be signing right on behalf of the company. I put Coldwell Banker's license. In case you did not know it, is 01121 690. Make sure that you write it down. Every document that you write and you put in Coldwell Banker George Realty must have this license number, okay? So, and remember, our name is not Coldwell Banker, it's Coldwell Banker George Realty, the whole four names. It's not Coldwell Banker George, it's not Coldwell Banker Realty. We need to use all four names. When you open escrow, make sure that it's Coldwell Banker George Realty. Our checking account says Coldwell Banker George Realty. And some banks are getting crazy about not accepting a check that doesn't match the exact name. So make sure that you always use Coldwell Banker George Realty. Don't be lazy. 01121 690. Of course, here I am the agent of the transaction, and then I put my license over here, and then I date it and sign it, okay? So this one is instructions to exclude the listing from the multiple listing service, okay? So that is gonna be one of the forms that we're taking today. I'm gonna go back. The next form that I would like to show you, of course, it's right here inside the listing agreement, but today we're not talking about listing agreements. We're talking about the addendums and amendments of the disclosures, right? This is one of the most important disclosures. By law, every real estate agent have to follow civil code, the laws of the state of California, and so therefore we have to use this one. And we did not prepare it. CAR did not prepare. This is exactly the way the law it's written. This was people in Sacramento, all those lazy people that are there in Sacramento, making laws and making all these crazy propositions, are the ones that created this one, right? Now, in the event that you're doing a lease, make sure that you check the box. If it is a lease, a property for lease more than 1 year, check it. If you are in, most of the time we sign a lease prior to the beginning day and it ends in 1 year, I would do it and I provide this agency relationship to the tenant, to the landlord, okay? Make sure that this is done. Now, of course, this one is the seller's company to the seller. There is one that says buyer's brokerage firm to the buyer. And those are the only forms that get signed. In the old days, we used to have them signed by both parties in the transaction. Today, if you represent the buyer or the tenant, all you need to do on the bottom over here will be the buyer or the tenant, or if you represent the seller or the landlord, all you have is the seller or the landlord. You do not need to have buyers sign here unless you're representing the both people and you're using the same form. Okay, so this one is the civil code requires that we give this form, and it expels out our duties and responsibilities. And we have duties and responsibility to both the buyers and the sellers, and the landlords and the tenants. Don't get caught up on the wording. Sometimes they refer as a buyer as a tenant the same way, and then the seller landlord. So it says a seller's agent, it could be a landlord's agent, under a listing agreement with the seller, acts as the agent for the seller only. A seller's agent or a sub-agent of that agent has the following obligations. To the seller, We owe them a fiduciary duty, almost care. That means we have to be very careful when we're doing business with people. Integrity, honesty. We don't lie, we don't cheat, we don't deceive anybody. We tell the truth 100% all the time, every time. And loyalty in dealing with the seller, right? We need to be loyal, honest, have integrity, and utmost care for people. To the buyer, even though we are the seller's agent, we owe duties to the buyers and the seller together. We owe a diligent exercise of reasonable skills and care. That means that we need to know. Reasonable skills is you need to know your craft. You need to know real estate in order to represent somebody in performance of your duties. What are your duties? You need to know those things. The next one that you have is you have a duty of honest and fair dealing and good faith. Okay, you have to be dealing good faith. You have to be dealing out, outgoing person with the truth, not hiding, not quieting certain things. If you know something that affects the transaction, it is your obligation to bring it up. And in real estate, everything has to be in writing. So all disclosures must be in writing. And you also owe a duty to disclose all the facts known to the agent, materially affecting the value or desirability of the property that are not known to or within the diligent attention and observation of the parties. An agent is not obligated to reveal to either party any confidential information obtained from the other party that does not involve the affirmative duties set for above. Like, for example, I am getting divorced and I am selling my house, and I'm gonna tell you, listen, I don't want anybody to know that I'm getting divorced. I am the seller and you represent me, and I want you to handle that with utmost confidentiality. You cannot reveal that to anybody, please, okay? And if the buyer says, what's the reason for selling? Well, you give another reason. You say, I don't know, but they have to sell. That's all I know. So make your best offer, okay? Now, if you're representing the buyer, you are the buyer's agent, okay? A buyer's agent can, with the buyer's consent, agree to act as the agent for the buyer only. In these situations, the agent is not the seller's agent, even if by agreement, the agent may receive compensation for services rendered. This is not a contract for money. This one's only spell your duties, okay? So it doesn't matter who pays the commission. You can represent the buyer exclusively, and then the seller's agent is giving us our commission because we belong to the multiple listing service and we get paid by bringing an offer, okay? An agent acting only for a buyer has the following obligation. To the buyer, a fiduciary duty, utmost care, integrity, honesty, loyalty in dealing with the buyer. So basically it's the same obligations that we have. If we represent the seller, we have a fiduciary duty to the seller. If we represent the buyer, a fiduciary duty to the buyer, right? And then to both people, we owe the same duty of honest, fair dealings and in good faith, diligent exercise of reasonable skills and care in performing our duties. And then we have a duty to disclose all the facts known to the agents materially affecting the value or desirability of the property. Now, if we are aware that there are airplanes going every night on Monday through Friday, but we're showing the house on a Saturday and it's so quiet, your duty is to say, by the way, during the week, there is airplane noise, okay? Oh, do you mind? No, I don't mind. I love planes. Perfect, no problem, okay? And if you wanted to put it in your AVID, then you go ahead and on the AVID, you tell them, I explained the client that I have, that there is noise from airplanes, right? Now, if you are representing both, right? An agent representing both sellers and buyer, either acting directly or through one or more salespersons and brokers associates, can legally be the agent of both the seller and the buyer in a transaction, but only with the knowledge and consent of both sellers and buyers, right? Remember that after this one, there is one document that says consent to represent more than one buyer and seller. That's the reason why we want that permission to represent people. In a dual agency situation, the agent has the following affirmative obligations to both the seller and the buyer. Technically, they're the same, only that you are the only person handling it. Now, it doesn't say that you, Caesar, is the only agent. It could be Lori representing the seller and Caesar representing the buyer. And because we both work for Coldwell Banker George Realty, Coldwell Banker George Realty becomes the agent. We are both representing the buyer and we are both representing the seller, even though I have never seen Lori's client in my life. I don't even know, how that person looks, but he is being represented by me as well. So I have to do my job, do my duty to the best of my ability, utmost care, integrity, honesty, and loyalty, right? The other duties to the sellers and to the buyers that were stated above in the respective sections. In representing the sellers and the buyer, a dual agent may not, without the express permission of the respective party, disclose to the other party anything that is confidential. Remember when I said divorce, or I'm losing my job, I got fired, I got no money, I got nothing, but I need to sell my house, right? So that is a confidential information that I do not have permission to tell the other person, okay? Or if I tell you, listen, I'll sell the house for $100,000, but don't tell anybody, okay? That's confidential. I will make decisions on the offers. And remember, they may change their mind too. And even though they confided on you that they'll take 100, when an offer comes along, even for 100, and you say, hey, you told me you will take 100. Well, I changed my mind. Oh, I already told the buyer that you would take 100. Oh, you violated that confidential information. So do not ever violate the confidential information. And then here is not only about us, about agents, it is also about them. The sellers and the buyers have responsibilities and duties. It says either the purchase agreement or a separate document will contain a confirmation. This is very important because this confirmation expressly tells the buyer and the seller who is representing them, okay? And this gets done at the time of the purchase agreement, of which agent is representing you and whether that agent is representing you exclusively in the transaction or acting as a dual agent. It says, please pay attention to that confirmation to make sure that it accurately reflects your understanding of your agent's role. The above duties of the agent in a real estate transaction do not relieve a seller or a buyer from the responsibility to protect themselves. I mean, just because I have an agent doesn't mean that the agent is going to look after for me. I, as a buyer, I, as a seller, I'm an adult. I live in the state of California. I got to follow the rules of the state of California. You should carefully read all the agreements to assure that they adequately express your understanding of the transaction. And then he says the same thing, right? A real estate agent, okay? Oop, I wanted to come this way, see if I can, anyway. No, I don't want to blue the other part, but I said a real estate agent is a person qualified to advise about real estate. If legal or tax advice is desired, consult a competent professional. We are telling the buyers, that's the way I wanted it, right? A real estate agent is a person qualified to advise about real estate. If legal or tax advice is desired, consult a competent professional. I wish it would say, if you want building information, if you want anything, consult the contractor, a building inspector. If you're talking about electricity, roof, I am not a roofer, right? I am a real estate agent, so I can only give you advice about real estate, all right? If you're a buyer, you have the duty to exercise reasonable care to protect yourself, including as to those facts about the property which are known to you or within your diligent attention and observation. Both sellers and buyers should strongly consider obtaining tax advice from competent professionals. Make sure that they go to a CPA, not the guy in the trailer that does income taxes just once a year, okay? Because the federal and state tax consequences of a transaction can be very complex and subject to change, right? And then throughout your real estate property transaction, you may receive more than one disclosure form. You will be getting, depending upon the number of agents assisting you in the transaction. The law requires each agent with whom you have more than a casual relationship to present you with this disclosure form. You should read its contents each time it is presented to you, considering the relationship between you and the real estate agent in your specific transaction. And then in big letters says, this disclosure includes the provisions of section 2079.13 to 2079.24, inclusive of the civil code that are on the page number 2. Please read it carefully. And then they sign saying, I acknowledge the receipt of a copy of this disclosure and the portions of the civil code printed on the back or a separate page, right? Now, imagine they are signing that they have read and understood sections 20. They're better than lawyers. So here it is for your pleasure. Section 2079.13 to 2079.24. Tonight's homework. Monday, do not watch Dancing with the Stars. You need to read this in order to be the best agent you can be, right? It says 2079 appears on the front of this form. So the whole thing, what does agent means, right? What does buyer means? So real property it is. You know, what are we talking about? A seller's agent and a buyer's agent, right? Shall provide a copy of the transaction, copy of this disclosure. So all of the rules, and then this confirmation, I'm pretty sure that you've seen it, right? This confirmation, up to here, comes up where? In the purchase agreement. So if you look at a purchase agreement, that's where the confirmation is gonna come out, right? The seller firm, click, seller's agent. If you are the buyer's broker, you represent the buyer, both agents. Remember, don't forget the license numbers, and this goes into the purchase agreement. By law, this is the way they want it. So we adapted that and we put it in the purchase agreement. So this is the entire disclosure regarding real estate agency relationship. Page number 2. Remember, when the buyer signs here, and the Sally will sell, the seller or the buyer sign here, they are saying that I acknowledge that I have received a copy of the disclosure and the back page of this one, okay? So make sure that they get copies of front and back of this form, all righty? So congratulations, now you know how to do a disclosure regarding real estate agency relationship. If you have any questions, don't forget to put them on the chat box. And at the end of a couple of other forms, I will go back to the chat box or at the end of the training, and then we can discuss it. If at any time you have a questions, feel free to interrupt me and we can do it. Now, the next form that I like to do that is this one, which is the possible representation of more than one buyer and or seller. It's a disclosure and consent. This is when the buyer or the sellers give permission for us to become dual agents, okay? So we need to have this form in every single transaction because we are a company, we are an agency of over 350 agents, and I don't know what Doug or Lori may be doing. They don't know what I might be doing. We might have a set of twin people that are looking to buy the same type of property. So we need to tell them that there could be multiple buyers looking for that property, okay? And then it says consent. That means they give us permission to represent them both, or that there will be other people competing with the property, buying the same property, right? So here, dual agency. If the seller is represented by the broker, meaning Coldwell Banker George Realty, sellers acknowledge that the broker may represent prospective buyers of seller's property and consent to the broker acting as a dual agent for both the seller and the buyer in the transaction. If the buyer is represented by the broker, buyers acknowledge that the broker may represent seller of the property. The buyer is interested in acquiring and consents to the brokers acting as a dual agent for both buyers and sellers with regard to that property. Okay, so that means this is a possibility that we can be representing more than one buyer or more than one seller. And also they give us the permission, the consent. I give you permission to do that, okay? And it will be on the purchase that the seller signs, the buyer signs, The buyer's broker have to sign. If I would be representing the buyer, I will have to put here Coldwell Banker George Realty. I would have to be putting here 01121690. And then over here, I am the agent, so it will be my name. Okay, and there will be my license over here. And if over here, the same thing, it will be, I'm the agent, and I'll put my license over here. Make sure that you date. Make sure the dates are very important. Don't leave them blank. Pay attention to your transactions. Remember over here on the agency, what does it say, right? Look at this one. Utmost care, reasonable skills. Reasonable skills of even filling the form correctly, putting the date, that's a skill, right? Or be careful, you know, right here, care. Don't be careless. You need to care and make sure that you always put in the dates, always put in the license number. That's part of your job. If you ever go to court, the attorneys are crazy. They lined up everything that you didn't cross the T, and they say, well, you didn't have any care of for these people. You know, didn't care about the transaction. You didn't even fill up the date. Bam, jury. This guy don't know what they're doing. Guilty, right? So they use every little thing to get you into trouble. So please, please, please be careful when you're signing documentation, right? Of course, we talk about this one. You need it when you're writing an offer. You need it when you're presenting a listing. It is called wire fraud and electronic funds transfer. It's just an advisory. This one is not a disclosure. Remember when I say an advisory is grandma telling you, make sure that you put a sweater. It's cold outside. You're going to catch a cold. Okay, so make sure that we follow grandma's advice. Don't touch the stove. You're going to get burned. Hot water, you know, be careful. So these are things that happen. Be careful, Mr. Seller, that Los Angeles County is the fraud capital of the world. California property values go up pretty high. If they go up by 10%, a $500,000 home is $50,000. So there's a lot of criminals out there that will, you know, kill you for $5,000. So there they are. And so you read the form and you tell them that there will be wires from escrow, from title company, and they can choose to, you know, walk a cashier's check. Escrow company can walk them through how to make sure that they don't fall victims of wire fraud. Okay. But look at it. You can, if you have any more questions, you can call the FBI. So if anybody want to call the FBI, that's the number for the FBI here in Los Angeles, 310-477-6565. Or you can call the National White Collar Crime and go to the internet, right? You go to the internet, or you can go to this another website and look at what they do. It On Guard Online, Gov, anything that finished with Gov is the government, so you can look into that. And then it says there are existing alternatives to electronic and wire fund, cashier's check, signing below the undersigned acknowledge that they have read, understand, and have received copy of this wire fund electronic money. Buyer sign, seller sign, that goes into your file. We need to have this document in every transaction that Coldwell Banker George Realty does, okay? No excuses. Please make sure that you get it. Please make sure that you get all your paperwork within the first 15, 17 days of a transaction. That's when everybody is on a honeymoon. That's when people are happy. At the end of the 30 days, people have a little trouble, and that's when they don't want to sign documents. So get them signed ASAP, okay? The next document is not the residential listing agreement. We don't talk about it today. You know, remember there's several pages of 5 pages of the seller giving us permission to market the property, but there is a document after that, which is called a seller's advisory, more advisories. Grandma likes to talk and tell you, do not go out with strangers. Don't talk to strangers. So this one is about it, right? So CAR has a whole bunch of advisories. In my opinion, they should put them all together, make them, you know, and get one signature at the end, just like a little earthquake booklet. They should have all of these advisories in one, and that way it will be easier. You know, even if it is 10 pages of advisories, it's better than just changing them. But this is the way they do. General disclosure duties, right? And it tells a seller, you have to disclose to the buyer in writing. Everything is in writing, guys, okay? Any known facts that materially affect the property. There are duties by law, cannot exempt. By law, 1 to 4 property, you have to give the buyer an NHD. They have to give the buyer a TDS. They have to be the buyer those forms, right? So the seller has to give those information to the buyer. No way around it. So we let them know. I'm advising you, Mr. Seller, that in this transaction, you would have to give a lot of disclosures to the buyers of the property, right? We give them a guide for home earthquake, property guide of earthquake safety, protect your family from lead in your home. So all of this information is given to it. Oh, the properties in a Mello-Roos Community Facilities Act, right? We give them about the improvement bond of 1915, you know, that was, my grandma was born in 1915. So in a notice concerning the contractual assessment provided by section of the Street and Highway Code, how would I know? A special tax disclosures. So that's the reason why when we're writing an offer, we tell on the offer, it says seller to provide this to the buyer. You know, get that information in the purchase contract so the seller will have to give it to us, okay? Transfer disclosure, NHD, lead, military ordinance, right? All that information has to be given to the clients. And usually it says the buyer will have 3 days after they give it to them to read it and to determine whether they like the house or not. So technically, if you give me a disclosure, I give to the buyer, buyer reads it and I say, oh, I don't like it. I want to cancel. Then you cancel. But it has to be done with the days. Don't change that information, okay? Condominiums, if the property is condominium, you make sure that you gotta tell the client. Sometimes it might be looking like a beautiful gated community. Every house has a lot, and you think that it's single family homes. It may be a condominium. It might be subject to a common interest, okay? Same thing goes with death and other disclosures, right? You have to give that information to the buyer by law. Look at it, California Civil Code right here. Whenever there is a California Civil Code and there is a number, if you have doubt, go read it, okay? Contract terms and legal requirements. So Mr. Seller, Mr. Buyer, make sure that whenever you make a contract, you have to follow it, right? If you are a foreigner, withholding taxes. If you, okay, no discrimination. In California, there's about 17 clauses and probably 18, 19, 20, or 29 or whatever. You know, we do not discriminate sex, creed, national origin, religion, political affiliation, you know, anything. We don't discriminate. If they are approved for a loan and they have cash down payment, we take it, okay? Doesn't matter, that's all we look at. Money, are you qualified to purchase? Can you buy the house? Lead-based paint, same thing. We said it again here. Any property that was built before 1978, okay? Legal and tax and other implication, right? So we let them know, hey, selling your property may have legal, tax, insurance, title, other implication. You should consult an appropriate professional for advice on this matter. Every piece of paper that we do, we tell them that. And it's just because we don't want to get sued. Oh, the agent told me, the agent told me. Telling is not the same thing. What's in writing is what is valid in a court of law, okay? And then we tell them, the seller, hey, please make sure that you do an inspection of your house. You can be fixing stuff. I wish all the sellers, whether it's a buyer's market or a seller's market, before selling their home, they will call an inspector, have an inspection. If there's a couple of items, they should fix them. And then say, hey, the inspector told me to fix here, I fix it. And I attach this as part of the transfer disclosure statement. That would be a wonderful way of doing business. But I don't control this business, right? That will be my perfect world. Seller should give the buyer the house already with all the items that need a repair, just like a car. Oh, it's leaking oil. Well, I wash it and it's clean. No, it's leaking oil, and I let you know that. Disclose, okay? Safety precaution. We tell people about advertising, marketing, photos of your property. Don't leave, don't leave valuables, vandalism, damage, and other harm to the property. We let them know that in writing. See, we couldn't be speaking all of this on a listing presentation. Otherwise, it will take us about 2 days. You make an appointment. I'm going to list your house on Friday, and I'm not leaving your house about Sunday. So make sure that I have a brunch with champagne, with mimosas, because I'm going to spend 3 days explaining you all the paperwork, the disclosure. It's going to take me about 25 hours to read every single line of this one. What you do is you go on a listing presentation. You should do a listing presentation no more than about an hour, hour and a half. Present the CMA, present all the paperwork, sign, 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 sign. You leave them a copy and you hand them a copy and you say, if you have any questions, don't hesitate to call me. We are already in a contract for 3, 4, 5, 6 months. If there is any problems, I'll come back and fix it. And if they have any questions, you can always amend the contract. We can always amend the disclosure. Oh, we forgot to tell you that the roof was leaking. Okay, then make another TDS and say the roof is leaking. So that those paperwork can be corrected before we give them to the buyer. Okay? Same thing, the seller will sign them. The listing company will do that. It's between the seller and us that we're giving all these advices to them. And of course, at the beginning of 2020, there is a form called the California Consumer Privacy Act Advisory, right? By law, civil code. Hello, civil code. That's where the people in Sacramento, they write the rules of how you should live your life. 2035, you need to throw away your car and get an electric car. That's the law in the state of California. So I will be too old to drive anyway, but tell your kids and your grandkids not to buy gasoline cars. That's what the governor wants. And he says, as of January 1st, 2020, the California Consumer Privacy Act grants to California residents rights in their private personal information that is collected by companies with whom they do business. Under this CCPA, personal information is defined broadly to encompass non-public records information. That means like social security, birthdays, all that personal information. If by any chance you use it, that gotta be shredded. Make sure that it doesn't be told to other people. So make sure that you keep it. Don't leave it on the copy machine. Sometimes I find an entire tax return on the copy machine. Please don't do that. Take care, utmost care, integrity, loyalty. That's your job. If you embrace those things, you will handle the business correctly. You will be a top producer and you will have all the people doing business with you. Okay. So we're going to submit information to the multiple listing service. So we explain here to the seller, tell the seller, please read it. Now you should be able to paraphrase this form just by saying, hey, the California Consumer Privacy Act, if any private information that you give me, I will shred it. I will never use it and share it with anybody else. Our staff, our company managers, our company transaction coordinators have been trained to make sure that nothing leaks out of here. That's why we use SkySlope. That's why all the files are kept electronically somewhere out there in the cloud so nobody can grab them. You can fly to the clouds and get the paperwork, okay? So if there is an MLS, business or third party, you have the right to be notified about the sharing of personal information. Technically, we do that when we're doing the listing, okay? So when we do the listing, we're filling out all that information and we tell them your property will be exposed to the internet, your property will go here, and that's why they give us permission. That's why so many papers have to be signed by the sellers and us to make sure that we handle the transaction correctly. Of course, they are going to be signing there, dates and signatures, and we want to collect all this documentation at the time of the listing. We want to make sure that the buyer signs all their disclosures before they're presenting the offer. Make sure that you got all of the stuff that you as a buyer's agent needs to do before you write up a contract. And when you're writing the contract for the buyers, okay? Then you go back. There was a lot of information there. Any questions? Anybody has any question? Everybody's asleep, everybody's awake. This is only for MLS, correct? What if the sellers only want to put it on MLS and doesn't want to put up a sign? Do we still have to fill out a disclosure? Jesus Jurado, your question. You can unmute yourself. I don't know. If they don't have to put a sign, of course they tell us we don't put a sign, and that's okay. This one is not to be advertised on the multiple listing service. That was that form was about. Exclude from the MLS. Did I answer your question? I hope I did.
Yeah, you did. Thank you.
Beautiful. Okay. I'm going to continue. I'm going to go back to share. If any other questions, I'm going to go back to sharing my screen of the MLS, share, and I am going to the Coldwell Banker addendum. A lot of questions, a lot of misinformation in the company. This document is to be signed by all Coldwell Banker George Realty transactions. It protects you. If you don't understand it, read it. Statement number 1, right? It says buyer subsequent purchase. In the event this transaction is not concluded within 12 months following the date of this offer, buyer or any related person, any relatives acting directly or indirectly executes an agreement to buy the property or any interest in the property from the sellers or sellers' successors in interest, buyer hereby agree to pay to the broker. This protects your commission. The commission is specified in the agreement. For purposes of this agreement, related person include any person related by blood, marriage, or business relationship, and any entity which control or is controlled by the buyer. So this paragraph says the following. You write up an offer. You include this document. You go offer, counter offer, offer, counter offer, and the deal goes sour. Betty Buyer is buying the property. And Betty gets upset at me, and Betty goes out, you didn't get me the house, and blah, 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 whatever. So what happened is that a month from now, I see that the property sold. And I go to the county recorders. I tell my title people, can you see who bought that house? And guess what? Betty Buyer bought the house. Oh, brother. That means that Betty owes me my commission that I would have earned by her signing this paragraph. And then I can go and sue her in small claim court if it's less than $10,000 and go sue Betty and say, Betty, you bought the house that I show you. You bought the house that I wrote an offer. You bought it with somebody else. You bought it with a listing agent. You bought it directly from the seller, but you still owe me a commission because I got this paragraph that says that you bought it and you owe me a commission. And that goes if Betty Sisters buys it, if Betty Cousins buys it, or Betty LLC buys it. If you put in the address of the property and you get Betty signing over here, your commission is protected. That's how this form works. You need to read it, okay? So this paper needs to be signed at the time of writing the offer, and it goes with all of the transactions, number 1. Number 2, it says inspections, right? So we are telling the buyer, dear Mr. Buyer, you need to inspect the property, okay? I am not responsible for plumbing, heating, electrical, anything like that. So we tell them 1 time, 2 times, 3 times, 5 times. Inspect the property. You're an adult. You live in California. You need to do it. Number 3, we talk about the value of the property. You're buying it for $500,000, $1 million, $2 million. I'm advising you that you are the one making a decision for how much to pay for the house. Buyer and sellers acknowledge and agree that even though the broker provides you with information, we give them comparables. They are responsible for the price they're offering, and they are responsible for the price that they're accepting. That's an agreement between a buyer and a seller. not the agents say so. So we are telling them about the value of the property. Number four, how many times do I say, go to Moy Escrow, go to Central Escrow, go to this escrow company, use Sandy from First American, use an, Central Escrow, use this escrow. So we are not endorsing those companies. Hello, we need to be protected in the event that those companies do something wrong. If that company do something wrong, it says buyer and sellers acknowledged. Although the broker may suggest the company, we are not responsible for whatever escrow, title, pest control, geological inspections. We are not responsible. We don't assume responsibility for performance of those suggested companies. Number five, right? Additional environmental hazards. We don't know. I mean, even the state of California, when you go to the gas station, they put a poster that says Proposition 65. It is known to the state of California that if you pump gas into your car, you're gonna die of cancer. Hello? Everybody puts gas into their car. Everybody's gonna get cancer. Well, that's what the state of California. So we need to clean up ourselves, and we gotta tell the buyers. The parties are advised that the presence of kinds of molds, fungus may adversely affect your property, your health. So we don't wanna get sued about those things. Broker recommend that if the buyer has any concerns regarding this issue, that the buyer conduct further inspections by qualified people. If you're concerned about anything about, I don't know, the paint, the carpet, the wood for the kitchen cabinets, the stove, the microwave, I don't know, this country is going crazy about lawsuits. So we want to make sure that the buyer signs it and relieve us from liability. Now, same thing, 1031 exchange advisory. Sometimes we deal with a seller that lives in the property, but his brother lives in New York. Haha. And the brother co-sign and is part owner. And then when it's time of escrow closing, escrow is gonna say, wait a moment, you get 100% of your money, but your brother in New York, it's gonna have a withholding of 3 1/3% because you gotta pay taxes in California. Oh, the seller is gonna say, or the seller brother, oh, the agent didn't tell me, and they get all upset at you. Oh, excuse me, I told you on number 6, on the Coldwell Banker George Realty addendum, there could be some tax consequences. I told you to go talk to your accountant. There we go, you are a professional. Number 7, again, tax legal consequences. This is about the 7 times 7, like in the Bible. We tell you, consult your tax advisor, consult your lawyer on every real estate transaction, and we get a contract. Rent control, oh my God, and even now we have rent problems in the entire world, I mean, excuse me, in the entire state and the entire country, because we have a CDC, the president decided that no evictions. Well, here's problem with rent controls. There are problems with a 5% in excess. All of that, we told them, please check with the law. They are responsible to check, not us. So we let them know, hey, watch out for this. Yes, yes, yes. Everybody's bitching about the 295. And I said the word bitching, but it is a fee, an administration fee that Coldwell Banker George Realty likes to recover, okay? Because commissions in the old days, it used to be 6%. And the real estate agents are cowards and they're dropping their price. And the market is dropping the price of our fee, okay? We still, I mean, an agent that makes $100,000 today, is as a top producer. Back in my times, an agent produced $100,000 was a top producer, but we haven't gone higher than 100. We should be making $300,000 and $400,000 every single one of us. Okay, but the commission keep coming down. So the company decided back before 2011, okay, that we were going to charge a $295 transaction fee. It is not a transaction coordinating fee. It doesn't go to the person that does the employees of Coldwell Banker George Realty do not get a single dime out of this money. It is just administration fee, so we can have the sky slope, so we can have the broker version of these forms, so we can handle the transaction and we can store them. Now we store them electronically. So if a client wants it, we will give it to them. If they did not pay the $295 and they want to have their information, we will charge them $295 to give them those papers, closing stuff. So it's right there, read it. Document compliance fee, it's at $295. If you have questions, we can handle them at the end of the training. Seller financing, in some cases, the seller finance property if the buyer is short on the down payment. Zoning, the same thing about zoning. Oh, I want to buy this house and then I'm going to build a school in this corner. I'm going to do a health care center. I'm going to do a senior housing. I'm going to have a birthing house and have all the pregnant lady live on this house. Zoning may have a trouble with you. REO sales, we don't have that many now. I don't think we're going to have short sales. I don't think we're going to have because equity has gone up for a lot of people. Probate sales, if it is a probate, trust sales. So Mr. Buyer, if you're the first time buyer, you shouldn't be buying houses that you're not aware what's gonna be coming here, okay? If you're an investor, yes. We're talking about aircraft noise, train noise, freeway noise, rural wildlife, right? I live in Glendora and I get the bears swimming in my swimming pool. Or I live in San Gabriel and I get the coyotes and they're eating the cats, the neighbor's cat. That's wildlife. So you need to be protected. Oh, I didn't know. The agent didn't tell me that there was gonna be squirrels in my front yard. Gusty winds, sometimes we get them. El Nino year, winds, you know, tornadoes, whatever, landfill. Some of the people that live out there in Monterey Park, Montebello, Hacienda Heights, Roland Heights, they used to be trash deposits, right? They were landfills. And then on top of the landfills, they put dirt and rocks and more dirt and they build houses on top of it. But underneath, there's a lot of trash 20, 30, 40, 50 years ago. So watch out for those things. Privacy notices. This is exactly, Coldwell Banker was using this privacy notice since before 2011 and just came into law at the CCPA, right? The California Consumer Privacy. We had it here for many months. This document protects you, protects us, okay? And then the same thing about vesting. Do I own it joint tenants, tenants in common, you know, in partnership, whatever, vesting. We are not telling them how to own property. So this document is very important and every transaction should have it, okay? So we are closing it. The next document that I like to do is it's a representative capacity signature disclosure. In the event, of course, this one says for sellers representatives. There is one that it says for buyers representatives, and it's right, especially the same, just over here, it doesn't say when you're representing the buyer, it doesn't have this box that says at the time of the listing. It only has this one that says at the time of the sale. But anyway, the form is exactly the same. At the bottom of the form is gonna be RCSD, and instead of the S, it's going to be, I'm sorry, I should have it big. I totally did not do that on the previous document because I don't think I can do full screen on that document. But on this one, the form is RCSD buyers. When you're representing a LLC, when you're writing an offer as an LLC, you must have this form. When you are representing an entity, you have to have this form. And the entities are, it could be a trust, it could be a corporation, it could be an LLC, a limited liability company, it could be a partnership, or it could be other, I don't know, whatever you want it could be. They have authorized that officer or a managing member or a partner on that LLC, on that corporation, or the person is signing is acting on the behalf of the company. And that person has authorizing resolution, right? So sometimes the title company might require that you have a corporation resolution that says that, you know, Peter Cam, it's authorized by, you know, the corporation, High-Ten Partners Inc., to be the manager of Coldwell Banker George Realty, to be the president of Coldwell Banker George Realty, to sign on behalf of Coldwell Banker George Realty. That's what this form is all about. Or my sister lives in, you know, Panama, and she said, hey, the sister is giving authorized a person signing below to act as my representative, with powers of attorney, to act on my behalf, pursuant to general powers of attorney. and you might need a specific power of attorney for the property, okay? And it has to have a date. Title companies usually in real estate transactions do not like the general power of attorney. They like a specific, just for the purpose of selling this house, okay? For the purpose of borrowing against this house. They like to have a specific attorney, a specific power of attorney. And it has to be dated, and they don't like it to be more than 6 months, okay? So this form is not a power of attorney. This is just to tell people that they are representing that entity. So you either check one box, or you check the other box, or you check this box, or you check this box. And then once you check this box, make sure which one applies. For those of you, if I am representing a state, that's on a probate, right? If I am representing somebody that is ill in a convalescent home that don't have it, I get a conservatorship. And if I'm representing a minor, it's usually a guardianship, a minor, somebody less than 18 years of age that owns a property. They need to have a guardian sign on their behalf if they're not emancipated, okay? And it has to be Superior Court, and it has to be a case number. So make sure that you have that information. And escrow title company may ask you for those documentation, okay? So make sure that you ask the seller for that information, okay? And then of course the seller have to sign over here, and the person representing the entity have to put their name and what they are. They could be the president, the trustee, administrator, whatever happens to be their title of that entity, okay? And of course, at the time of the listings, they do this. And at the time of the sale, they do this, and the buyer have to sign this, okay? Or any other time of the agreement. You gotta get signatures at different stages, depending on the transaction, right? If you have any questions, we'll address them in a little bit later. Seller's affidavit. Okay, so this one, the next form that I'm giving you is a seller's affidavit of non-foreign status. It's a FIRPTA. That's what people refer to FIRPTA. Oh, you need to provide me the FIRPTA. This came in effect in the 1980s. It's been already 20 some years that we need to do this. It was a law in the state because before a foreign person could buy property in America and then sell it for more money, and they used to take their money and they used to run. So the transfer disclosures, the affidavit, the FIRPTA, is a way of the government of keeping a withholding, and then at a later time, you can say, you owe me money or I owe you money, and get their money back. So in the old days, it used to be very simple. It used to be 10% of the selling price goes to the IRS, and on the state of California, 3 1/3% goes to the franchise tax board, right? But now, because of the government likes to make everything mess, they make it so complicated, right? The rules of this FIRPTA are in the back of the FIRPTA. Okay, and look at it. Federal guidelines. They're more confused than Pelosi. Okay, if people like that makes it, Pelosi and the other ones make laws, they have nothing to do but to be bickering about who has a green card, who is in the United States, how many days in the United States. I am an exempt individual because I work for a bank from Japan, and I am a worker, and I bought a house, and I sold a house. And imagine this. You could be physically present in the United States for less than 24 hours. If you're coming in a plane, and you are in the country, okay, where was here, look at it. 24 hours. When did you arrive? When did your plane come in? When did the plane left? He will not be treated as present in the United States. So you come to the United States, and you're only you're going from Chile to Los Angeles, and then from Los Angeles, you go to Taiwan. And if you are making a transfer and you are here for 23 hours on an exchange, moving going to Taiwan from Chile, right? You will not be treated if you were in the United States. Hello, I spend all day at LAX. Where is LAX located? You're not here less than 24 hours. The government is crazy, in my opinion, but I love it. This is the best country in the face of the earth anyways. But anyway, I criticize because I vote. I criticize because I registered to vote. So I used to have a green card, not anymore. So hello, hello. Closer connection to a foreign country. My God, if you're the ambassador, if you are whatever, you might have been here 183 days. And then they tell you how to count the days. So crazy. Non-resident aliens. Of course, you know, there's a lot of people in this office. We have relatives that are green cards, or we might be green cards. We are immigrants. We come to this beautiful country, but the rules are so difficult to follow, okay? So now they might even charge you more percentage, okay? Than 10%. It's almost as high as 15% of the selling price. So what if you, in the event that you are selling a property and the person is a foreign person, right? They need to talk to a foreign tax advisory, not just a regular CPA, but you need to talk to a CPA that is familiar with the treatment of foreign people, foreign taxes, because they might have to file a paperwork, the income taxes at the American embassy or whatever country they belong to. And they do that all the time. So don't worry about it, but you need to find a tax advisor that understands international law. If you are dealing with somebody that lives in Arizona and it's foreign to California and they're selling a house in California, they also need to talk to a tax advisor because they're going to be withholding 3.25%. And then at the end of the year, when they file their income taxes, they might have to file income taxes in the state of Arizona. They're going to file their federal IRS tax, and they may have to file a California return for the state of California. And that 3.25%, maybe they owe money and the government of California is going to say, you owe me money, or the state of California is going to say, here's your rebate. You don't owe me that much taxes, okay? So in the event that the seller does not want to give you this information, they don't want to give you their legal name, they don't want to give you their social security number, right? They don't give you their social security number. They say, no, I don't give my social security number to nobody. You say, okay, do not give me the form blank. You need to give me the form from the escrow company, or they will have to find another form. The other form is called qualified substitute. We found somebody, usually an escrow company. We found somebody, the escrow company is substituting, right? Like for those of you that know baseball, sometimes the pitcher doesn't bat. So they got a substitute batter. They have a designated batter that goes and bat instead of the pitcher. Well, escrow company is your designated batter. The escrow company is gonna sign over here and it's gonna say, under penalty of perjury, right? The undersigned qualified substitute. I declare under penalty of perjury, under the laws of the state of California, that he or she is in possession. I have in possession a transferor's affidavit, right? I know that these people are not foreigners. And then the escrow company will sign here. Some escrow companies don't like to sign our form. They have their own form, and that's okay with us. So Lori, you know, Doug and I will approve. Either you give me the FERPTA as a FERPTA form, whether you give me this form signed by the escrow officer, or whether you give me the escrow form for your file. No problem. A copy of that document should be given to the buyer, because unfortunately this law says that in the event that the seller is a foreign person and he goes to the Bahamas and he takes their money, the buyer is responsible for the taxes. So watch out, this government, they do little crazy things like that, okay? If you have questions at the end, I'll address those questions. to the best of my ability. Okay, we have another form over here, right? This form is called a market condition advisory. We need to have this form on every transaction for the sellers and for the buyers. So we tell the clients that we are, you know, the real estate market is cyclical. It goes up and down. Right now it's on an upswing. For the last, since 2012, for the last 8 years, the market has been going up, 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 up. I know people say everything that go up must come down, but it usually do not go down to the original level. At the beginning of the class, I was saying I bought my first house in 1984 for $69,000. Even though the market has gone up and down and up and down and up and down, you think I could sell it for 69,000? Heck yeah, I'll sell it for way more than 69,000. You know, it's probably worth about 600 today. So the market, even though it dropped, it's already at 600. So property goes up and down, most of the time go up, okay? So buyer's consideration. Mr. Buyer, you're making a price. As a buyer, you are responsible for determining the price of you want to offer for the property, okay? Buyer is the person responsible to decide the price that they want to pay. Okay? Of course, you're going to help them. Of course, you're going to suggest it, but they're going to sign this paper, right? So make sure that we have this document in our file. The same thing goes, please do not put people, even though the market is very hot, on non-contingent offers, especially if they're first-time buyers, okay? In the event that the buyer cannot obtain the loan, or it's not happy with the inspection. If you remove contingencies at the beginning, you are putting the buyer in harm's way. This is used for somebody that is a little bit more experienced in the purchase of homes, right? Loan contingencies. If you give up your loan contingencies and you cannot get a loan, you may lose your deposit, right? It's right here. You may forfeit your deposit to the seller. Sorry, it's down, 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 down. Right? You can lose your deposit to the seller if you say no loan contingency or appraisal contingency. You may lose your deposit, or you will have to, the seller is not obligated. Look at here, the seller is not obligated to reduce the purchase price. The seller is not obligated to reduce the purchase price to match the appraised value, okay? So make sure that when buyers are signing these documents that you at least explain them, paraphrase them, let them know what's all about. Remember to get this paper signed at the beginning of the transaction, honeymoon time, not at the end. At the end, nobody wants to sign nothing, okay? Inspection contingencies, okay? We have contingencies and we don't want to weigh those contingencies, right? It says, it is your decision alone. You are on this by yourself. It says, it is your decision alone and cannot be made by your broker or real estate agent, okay? There are risks in writing offers, non-contingent offers. Understand that. Broker recommendation. We are telling, now we're the one advising them, right? Instead of grandma, it says broker recommend that you do not write a non-contingent offer. Also, in the event of multiple offers, right now, the market is on multiple offers. This is at times, meaning right now, the buyer may write offers on more than one property, even though the buyers intend to purchase only one. This may occur in a short sale when the approval process can take consideration of that. While it is not illegal, it is not illegal to write many offers, okay, on multiple property. It is not nice, in my opinion, and that's just my humble opinion. You don't go out with 20 girls at the same time, okay? You don't visit somebody in Pomona and have another girlfriend in Upland and have another girlfriend in Glendora and invite them to the movies on Saturday one, on Wednesday one. That's not my style. One wife, all the life. But anyway, you can do that. You can, you know, have multiple offers. Sales consideration, this one is for the seller. You are responsible for determining the selling asking price of your property, okay? So we tell them again, and remember, we signed the Coldwell Banker addendum, and we told them that as far as values. Of course, the seller signed, the buyer signed. This document should be addressed to the buyer at the time of writing the offer. It's not after. At the beginning, when they're writing the offer, this day, you know, this day is very important. I'm going to tell you something. If you date here and it doesn't have, you write the offer today and you have this form given to the client way after, an attorney can really, you signing it next month, and let's say you do it on October the 15th and you wrote the offer on September, and you're going to tell the attorney, hey, how come you wrote a non-contingent offer when the buyer was buying? He had not read this paragraph that he was going to lose his deposit. Ay, ay, ay. Mr. Agent, how come you did not give this form to the buyer on September the 25th? You caused the buyer some harm. If the buyer would have known this, he would have not written the offer. And now the buyer is against you. And you're gonna go, well, the transaction coordinator asked me for the form, so I did it a month later. Shouldn't you have done it the day of writing the offer and explain to the buyer what they were getting into? Oh, guilty. Throw them in jail. You know, agents, be kind to your clients. Make sure that they sign everything from the beginning. Make sure that they are aware of what they're doing. Making an offer is not just make them an offer. No, it's like serious business to write up an offer. Make sure that by the time a buyer writes an offer, they are willing to go with the transaction. They do want the house, they want to buy the house, and they're going to perform. If they don't perform, or if they're light, make an offer. If they accept it, then I'll move forward. Sometimes you might get caught. That's the reason why so many transactions fail, because we don't take the time to explain the buyer what they need to do. This one became law by now. Every property has to have it. This one is anything that was built before 1994. Water conserving plumbing fixtures. What are plumbing fixtures? A lot of people say, well, plumbing fixtures are faucets, toilets, sinks. You know, all of those are called plumbing fixtures. Not the pipe, but the fixtures, right? And they have to be water conserving. Too many people in the state of California are green, conserving. They don't let the water come down to Southern California. They'd rather throw it in the ocean, but they're conserving water. They throw the water to the ocean instead of giving it to the people of Central California and have some more vegetables, cheaper almonds. But anyway, that's my opinion. I hope that you guys are staying awake. I will be giving you a lot of crazy opinions, but that's just my opinion. Anyway, water conserving plumbing fixtures, it is required on every single family home that was built before 1994. You tell them in any multifamily and commercial properties. I know that there is a lot of commercial agents sometimes, or agents that are doing both residential and commercial. And they tell me, oh, that doesn't apply to commercial. Hello, read it, civil code. Civil code requires. It's not Caesar, it's not Peter, it's not the MLS, it's not the CAR, it's the stupid people that live in Sacramento. They want you to get one more paper in your transaction. So if you're upset at the paperwork, don't take it on Tuhan, don't take it on Anna, don't take it on Joan. Our transaction coordinators are doing their job, making sure that we are staying out of trouble. It's because of the law that we need to comply to make sure that our files are complete. Thank you. That was an advertising. Okay. So there are some exemptions, of course, if the property is a historical property and you have a, you know, maybe a lion paw faucet, 20 gallons every time you open it. But if it's historical, you don't cut the hands of the lion and put a new Home Depot faucet. Okay. So they are exempt, some historical. Water conserving fixtures, right? It is not a point of sale requirement. This confuses people all the time. Okay, so I am selling you my house. In my house, I have a big shower head. I don't know how many gallons to wake me up. When I sell the house, that shower head is not a water conserving, right? It's a water waster, a lot of water. But when I sell my house, I'm just gonna tell the people, hello, Mr. Buyer, the faucet, I mean, the shower head is not a water conserving. You're gonna waste a lot of water when you turn your shower on. I don't have to replace it at the time of sale, okay? It is not a time of sale, okay? The next thing is a carbon monoxide detector. Same thing, requirement, California law requires that every existing single family home, they have a carbon monoxide detector installed, okay? And before January of 2013, right? Duplexes, dormitory, hotel, condominium, tie shares after January 2013. So we are already in 2020. By now, they should even change the form and say, hey, every house need to have a carbon monoxide detector, period, okay? Of course, there are some exemptions, okay? If you have an all-electric house, an all-electric condominium, no carbon monoxide danger because the heater is electric, no gas burning, okay? Disclosure of carbon monoxide. The Health and Safety Code does not require a disclosure regarding the existence of carbon monoxide detector in a dwelling. However, a seller of a residential one who is required to complete the real estate transfer disclosure, the TDS, on a manufactured home, mobile home transfer must use the section 2A of that form to disclose whether or not the property has a carbon monoxide detector, okay? So we don't even have another form for carbon monoxide detector. Before we needed an extra form. Now on the TDS or on the manufactured home TDS, you can put yes or no, whether it has it or not. I think that every inspector of a house will say seller to provide a carbon monoxide, right? And sometimes you can just plug it in the outlet, and that is part of the law, okay? It's okay to have one like that. Compliance with the installation requirements, right? State building requires a minimum placement of carbon monoxide detector if applicable properties outside of each sleeping area on each floor of a multi-level dwelling. Okay, so every room, right, must have one. Every bedroom, sleeping area, every bedroom has to have one. And if it has 2-story, one on each floor, 3-story, one on each floor, okay? Local requirements. If you are in San Marino, if you are in Beverly Hills, if you are in West Hollywood, some of the cities may require more stringent. So you need to check with the city, local city. Call the building and safety of that city and say, hi, I'm a real estate agent and I need to know, I'm selling a house in your city. How many smoke detectors? How many? I'm sorry, this one is but you can do it with a smoke detector too. Carbon monoxide detectors, how many do I need to have? And what kind do they have to be? Some cities may require that they were hardwired into the electricity of the house. Do not use battery operated in some cities, okay? So make sure that you do that, okay? And of course, the buyer have to sign it and the seller have to sign it. Yes, this document doesn't have to be signed at the time of writing the offer. This document gets signed at the time of taking the listing for the seller's agent. And when you're representing the buyer, the seller's agent is gonna give you this form within the first 5 days after the offer is accepted. And then you have 3 days to sign it and send it back to the file, okay? The next document that I'd like to disclose today is the lead-based paint. Federal law. I got nothing to do with it. This is federal law. Any house that was built before 1978. If the condominium was built in 1990, do I need the form? The answer is no. If SkySlope says, please provide the lead form, you all need to do is tell me, tell the manager, tell the transaction coordinator, the house was built in 1980. I don't need this paper. No problem. We will put doesn't apply, and that's the end of the story. If you wanted to review your SkySlope file 1 week after you open the file, go through all the forms and you can tell the transaction coordinator, don't follow this one, not applicable because the property was built after 1980. And if you have the water conserving, if the house was built in 2010 or 2019, it doesn't need the water conserving, right? You don't need the water conserving. So this is the menu I was talking about at the beginning. My meal doesn't come with dessert. I moved the dessert out. I don't like to drink soda. I like a good glass of wine. So please bring me the wine. Don't bring me the soda. The transaction, for as much as we want to let you know what is required, they're not all exactly the same. So you have to do a little thinking. Think about the property that you're representing the client and see if it applies or no, okay? And this form gets to be filled in. It is part of the California Residential Purchase Agreement. We need to put the name of the buyer here. Even though we get it without a name, make sure that you put the buyer's name. Make sure that the buyer, if there is any, you can put non-applicable, right? That could be something that you want to do to show that you at least read the form. Same thing over here, not applicable. I don't have any reports from the city that says that this house has led, so you can do that. The buyers, the seller sign here. The listing agent also sign here. Listing agent sign. This one is USC 4852. Doesn't mean University of Southern California. No. It says United States Code. This is not civil code. Civil code is a state law. This one is a federal law. If you don't do it right, they'll send you to federal prison. So don't mess around with this form, okay? You don't want to go to federal prison. Too many people like Al Capone went to federal prison, you know, this one is for sales transactions. You can have it checked that the buyer waives the right to do an inspection for lead. Buyer sign, and then the buyer's agent sign here, okay? Same thing, US 4852 law. You have agent's responsibility to make sure that this is compliance, okay? Do not sell a house prior to 1978 without this form being signed, okay? Make sure that you do it. Of course, all the form, you know, look at it. Every form in the bottom. If you need tax advice, go check your lawyer. We're telling them every time, all the time, 20 times. So this is, make sure that the buyers and the sellers are aware of whatever they're getting into. It is a big transaction to sell a house. It's not easy. That's why you should not reduce your commission. You should not work for nothing less than, in today's market, of course, no less than 2% on either side. So multiple buyer listing and selling, no less than 4%, 2.5%, 3%, 4%. It's okay to charge the buyer's commission, okay? This one is an earthquake hazards report. This one is 2020 edition. I just want to call your attention, okay? It's a new form. Make sure that you're using the new form. The last one was 2005. That's 15 years ago. Be careful. We just had an earthquake not too long ago here in the Whittier Narrows area, El Monte, Montebello area. So make sure that now buyers may be looking for, is the water heater brazed? Don't answer, don't know, don't know, don't know, don't know. Go find out and open up the cabinet and see if the water heater is brazed and show it to the seller and say, yeah, it's brazed. Answer yes or answer no. If this is an electric house that does not have a water heater, you can put does not apply, okay? If your home has a bolted to the foundation, if you do not know, look at the book, page 15. It's gonna show you what a bolt look like, okay? Are the exterior crawl hole spaces creeper walls? You can take a look at page 17 and it's gonna show you. Show the seller these pages and they will know how to answer. Look at the question number 8 and question number 9. They have changed. Sorry, yes, I should have explained. Question number 8, question number 9 do not have answers, but it says This is to be reported on the NHD disclosure. Hello, guys. Now we don't have boxes to worry about. We shift the liability to the NHD company. Every time there is an earthquake, there is a new fault. They discover something new, fault. We don't know where they are. You can see them in the NHD report, okay? But look at this one. I like this one. Is your home on a hillside? And I've seen some stupid agents that answer don't know, okay? Hello, take a look at it. If the house on a hillside, it is on a hillside. And if it is on a flat street, it's on a flat street. Don't let anybody say, I don't know my house is built on a hillside. It's built in Highland Park on a hillside. It's in South Pasadena on a hillside sometimes, you know? So make sure that you answer the question, yes, no. And this cannot be answered by the agents on an electronic format. Once you email this form to the seller, it gets unlocked and the seller can click on the boxes, okay? The same thing goes when you send it via digital signature, the boxes are open and they can click, okay? So this one is the 2020 edition, okay? I am letting some people slide just because we prepared the old form, but come, you know, October 1, I'm just gonna be very serious about rejecting this one because this one became active a few months ago, okay? So I might reject if you have an old form. The next one is the receipt, okay? This one is gonna be just the receipt. I don't wanna see the old receipt. This one is the new receipt, right? Make sure that it is done because it has stuff over here. Look at it, they even apply, it says, for applicable transaction, it is necessary that you complete the FLD 11, lead-based pay. This is because government, okay? So make sure that we sign this, the seller sign, the buyer sign, and we're happy this goes back into our transaction. Now, we need this form even if the house was not built before 1960. Any buyer that we represent, if we represent the buyer, we need to give them the booklet. Everything about the guide for hazard earthquake, toxic mold, the whole thing, you give it to the buyer. Even if the house was built, you know, a year ago, we want to make sure that the buyer got a copy. If the listing agent doesn't give you a copy of the booklet, you can send it to them electronically. If you want an electronic copy, you can find it right here, okay? Okay, the book is here, earthquake booklet. It's right here. You can send it in, or you can go to zip form and you can send it from zip form anyway. Statewide buyers and sellers advisory today. I'm not gonna go through this one. I usually go through the entire form. This is homework for anybody that is in the real estate business. You should read this 10, 20 times and understand it when they ask you questions. When they ask you a question as what is formaldehyde? I don't even know how to pronounce it. I'm a foreigner. My English is not that good. What is formaldehyde? And it tells you that it's a substance known to the state of California to cause cancer. Oh, don't buy the house. Oh my goodness, it has formaldehyde. How do you know? You have to have an inspection, okay? Geological hazard. How would I know if it has geological hazards? Well, I am not a geologist. I'm not the lady from Caltech that talks about earthquakes. Inspection. So all of that, it's just reading and understanding. And if you have a question, call Google. Google, what is retrofit? You put retrofit in Google and it will tell you what retrofit is, okay? Swimming pool, security, safety. Now you need gates, alarms in the state of California if you have swimming pools, okay? When we have water shortages, right now we don't have, but pretty soon we will. Every 7, 10 years in California, there is a drought, okay? 1915 improvement bond. I told you about this one. Usually the NHD company will report on this. Title company will report on this on the preliminary title report. There may be assessments. Some of the cities back in 1919 started charging so they can build a police station, a jail, some of those stuff. And those cities that don't do that, now new developments may have a Melrose community district. They use this money, Melrose money, to build the parks. They used to build the highways, to build the roads, the new schools. They use all these community facilities, and it's an extra tax on property, okay? I am gonna go, and I'm not gonna explain this one because I usually explain this one when I'm doing the representing sellers or representing buyers. We go through that form. The other form that is very important is the transfer disclosure statement, and this one will be a form that needs to be filled in by code. The seller needs to fill it in, okay? The seller tells you, I have a range, I have an oven, I have a microwave, I have a dishwasher, I have a trash compactor. Please don't mark microwave if the microwave is gonna be on top of the counter and they're gonna take it like they're taking the plates. Satellite dish, okay? Very few houses have satellite dish. Everybody has cable this day. Septic tank, okay? Sump pump. Sometimes some people have a sump pump. Water softener, patio, decking, security gates, all those questions. You guys should be very familiar with this form. They ask a question, are you Mr. Seller, Mrs. Seller, aware of any defects? Any talk significant? You know, sometimes the word significant, I don't know, a little ant may be significant to some people. To other people may not be significant, you know, a crack, a 2-inch crack in the foundation. To some people, big issue. To some other people, no big issue. It's normal of California earthquake construction, okay? They don't care. Other people, oh my God, I got a hairline crack, okay, on the driveway. I don't know. It's to people. Beauty is on the eye of the beholder. Value is on the eye of the buyer, right? Values, sellers, they get value. So here you only fill in the information that you can fill in. The buyer, the seller will complete the information. Are you aware, Mr. Seller, of any room addition, modification done without building codes? Yes or no? Let the seller fill in this information and then let the buyer understand what they're buying. And if they sign here, then they will be okay. My problem I have with this form is that the real estate agents are not checking this box. Okay? They're leaving it blank. So maybe what I'll do is I'm gonna have it checked in the template, and that way it will stay that way. Agent, see the attached visual disclosure, and then we'll have a signature. I just come up with a solution to my problems. Most of the agents are doing that. If you click an X over here, I don't want you writing nothing over here. Because this is, if you were to check this box, right? Then you write something in there. If you check the box on the top and you start writing, you are contradicting yourself. So please don't do both. You can only have vanilla or chocolate. That's it, one or the other one. You cannot swirl it around. You want vanilla? That's it. You want chocolate? That's it, and then you type something in there. Cannot have both. Please don't do both. If you want to write something, you do it on your AVID, okay? Every transaction, if you are representing the buyer, should have 2 AVIDs, because sometimes the listing agent will give you one, and then you as an agent needs to do another one. If they choose not to do one, they don't give you one, we still have to have ours, and ours need to be signed by buyers and sellers. That's the AVID. Now this form, the transfer disclosure statement, you need to have one for each property. If you have duplex, you need 2. If you have a triplex, you need 3. If you have 4 units, you need 4, okay? 5 units, no TDS. 10 units, no TDS. TDS only, single family home, condominium, and then you're gonna use the manufactured home TDS, MHTDS, when you're doing a mobile home or when you're doing a manufactured home. Sometimes you may have a concrete and they do one of those manufactured homes. They need a MHTDS, okay? If you have any questions about the form, do not hesitate to ask your manager. I'll be delighted to help you out. Make sure that the agent sign here, the other agent sign here. If you're representing both, there's only one, so you can really delete, you can delete, and you don't use this one. I'm sorry, I should have deleted, right? If you represent both buyer and seller, you can go like this, right? And that will be fine, one signature per agent, okay? If you represent both, then this one will be you. If you represent both, only one. If another company, 168 Realty Inc., then here is gonna be the other agent, okay? If they don't do this right, we don't care. They are doing it, okay? They're the ones that are gonna go into trouble. Okay. The other form that is very important that the client do is the seller property questionnaire. Seller property questionnaire is for the seller. It doesn't say agent property questionnaire. So the person that have to fill it in is the seller. Yes, I understand. I'm going to be there for 3 hours, Cesar. Well, you can leave the form when you go in. If you do a two-step listing appointment, you say, hey, Mr. Seller, I'm going to leave you all this transfer disclosure statement. When I come into the listing appointment, in my presentation, I want to make sure that the forms are completed. If you see the forms that are completed, that means you already have got the listing. If the seller has not completed the forms, then it's going to be an uphill battle for you to take the listing. I don't know. Think of ways of engaging the people, right? Sometimes some listing agents go out to the property. I like to see your property 2 o'clock this afternoon, and then I'm going to prepare a market analysis, and then I'm going to come back tonight or tomorrow night. You can do that. And when you go the first time around, you can give them the agency, you can give them some of this information and say, by the way, tomorrow when we sign the listing, I am going to make sure that you do these forms, okay? If they say, okay, wonderful. Oh, no, we want to sign the listing first, no problem. That way you know a little bit of your, conditions that they're giving you or objections that they're giving you to the transaction. So make sure that the seller finished this, right? It says this form is not a substitute for the transfer disclosure statement. It is used by the seller to provide additional information when the TDS is complete. If the seller is exempt from TDS, the seller should complete an exempt seller's disclosure. Trusts are exempt when the original trustee passed away. If I am the creator of my trust and I am selling my own house and I live in that house, I am not exempt from this form, okay? That is the position of the California Association of Realtors Attorneys, the hotline, okay? They want you to, it is exempt if the original trustee passed away and the subsequent or the substitute, of the next trustee is the one doing it, okay? So the form is finished by the seller, complete by the seller. You should know that the seller completed the form. If they have any questions, you please answer. So read it, right? Is there any ongoing recurring maintenance on the property? Some of the people have drain problems and they have a tree in the middle of the front yard and the lines clogged up. Every year they have a roto-rooter cleaning the thing. Hello, there it is. We have a maintenance, a tree or pest control service. We have bees, right, that come in every year in our trees and we have to fumigate them. Maybe yes is the answer. And then if you have a yes answer, you need to have an explanation. You need to tell that to the clients, okay? All righty, it's 11:50 on this form. I am going to stop at this time, go back to the chat box, and if you have any questions, please, please, please unmute yourself and let me know. So I'm gonna stop right here and everybody wake up. Do I need to give the new tenant earthquake booklet and receipt? Interesting question, Anna. The answer is yes. Do we at Coldwell Banker Church Realty enforce this one? Yeah. Okay, Anna. The tenant in the state of California is given more rights than the buyer, almost in some cases. Okay, so this is a consumer state. The state of California is out to protect the tenant because they feel that the landlord is the bad guy. Okay, it's not protecting the tenant from the agent. It's protect the tenant from the seller. The seller is the bad guy. The seller is the bad guy. Ooh, that's what the government think. So they tell that the tenant needs to read bed bugs. You even have to do a bed bug disclosure on a vacant house. Can you imagine how stupid the laws are? But you have to give a bed bug disclosure to the tenants. You have to give a lead-based paint to a tenant. You have to give an earthquake to the tenant and make sure that the water heater is braced. You need to, I mean, it's so many requirements on a lease. My advice is you guys shouldn't be doing that many leases. You guys should be doing purchases because that's where we make more money. On a lease, we make very little money, and the paperwork is as difficult. And when a tenant sue you, they sue you badly. About 3 or 5 years ago, we had a lawsuit from a tenant that went to this house and they had mold. The seller, I mean, the landlord was aware there was a little leak under the kitchen sink or something. And what he did is he just sprayed a little bit of Clorox, you know, bleach on the underneath the kitchen sink. And then all of a sudden it got all black. And then the tenant was a nurse. So he went to a medical, and the bill for the medical, the grandma got sick, the son got sick, the wife got sick. They moved to a hotel. They charged the landlord an arm and a leg because the landlord did not disclose to the tenant that there was mold. And believe me, big case, big case. And of course, the E&O insurance pay all of the medical bills. It was like, I don't know, $40,000, $50,000. And then the agent have to pay the deductible on the lawsuit. So I don't want to see you guys. My recommendation, yes, we do represent tenants. Better yet, we do represent landlords. That should be your forte. Tenants, it's up to you. It is not my recommendation, but if you want to do so, it's up to you. Yes, it is quick money. It's a couple of $100s, and we need it sometimes. But sometimes the paperwork and going back and forth, showing the property and filling in the memo, move in, move out, it's more tedious than making a sale. I'd rather spend my time cold calling than showing tenant a house. Any question? Everybody went to sleep? I am so excited that we have a lot of people coming to these trainings. I appreciate you guys putting attention. I've heard positive comments. Any question that you have, hey, feel free. You can email me. You can call me. I want to keep up this. I mean, Coldwell Banker is known in the entire state, West San Gabriel Valley, that we are the company to be. We train agents because we want you to make a lot of money. We want you to be protected. We want you to stay out of trouble. You know, if you need any questions answered, we will try to get the answers for you. Doug, Lori, you know, Peter, the entire staff will guide you, hoping for the right direction. Okay. My advice to you: become an agent of the 21st century. We are already in 2020, 20 years into this century. Pretty soon this century is gonna go down, and technology is what's winning. Learn how to do a listing presentation using Zoom. Everybody can get a free Zoom account. Maybe it will force you to do a listing presentation in 30, 40 minutes, you know, because then at 40 minutes, your Zoom account ends. But I like to help you. if you want me to, for those in Alhambra, you know that I always review your documentation prior to any listing presentation. If you wish, you could always show it to Lori. She'll be delighted to give you some hints, some pointers. That way we can do a lot of transactions. Yes, the number of transactions are done. Prices of homes is going up. Interest rate is staying low. I'm pretty sure that between now and the elections, the whole country is in a little trouble. But after the election, no matter who wins, there's going to be an upspurt in real estate. I don't care if Biden wins. I don't care if Trump wins. Real estate is always real. People need a roof over their heads. Some people say, oh, Biden won, I'm selling. Oh, Trump won, I am selling. Don't worry. Half of the people on one side, half of the people on the other side. So no matter who wins, somebody on which side are gonna sell. So all you need to be doing is calling people just to say, hello, how are you? I was just wondering, I know you're home. How are you teaching your kids? Make a blah, blah conversation. And then, by the way, I am calling you to remind you, I'm still in the real estate business. Who do you know that wants to buy or sell a home? How about you guys? Are you growing outside of the house? You know, can I help you sell the condo and get into a house? Oh yeah, we're moving to Pomona. We're moving to Rancho. It's bigger houses over there. Then list the house over here and sell them something over there. You can give referrals. Oh yeah, we're moving to Arizona. Give them a Coldwell Banker agent in Arizona, pay a referral fee. We moving to Las Vegas, same thing. We moving to New York. My sister is selling in New York. Can they use an agent over there? Recommend a Coldwell Banker agent and get a 25% referral fee. Make some money that way. Okay? Any questions? Any comments? All righty. I want to thank everybody that is here. I thank Glory for always telling their agents that we have a training. And we will like to see you next Friday. We'll have something very exciting. So stay tuned for the class for next Friday, okay? Thank you.
Thank you, teacher.
Thank you.
Have a wonderful time. Take care.
Thank you.
Bye-bye.
Bye.